Over the years, we have fielded a lot of questions about conditions of release. And I want to talk a little bit about what that is and why it's important that people understand what it is and understand what kind of paperwork and documents and supporting evidence you want to bring in the front end of a case in a hurry. Generally, and sometimes this needs to be prepared overnight or within a day or 24-hour period. Sometimes you have a week to prepare for this. So conditions of release are really when somebody's either in custody and in jail and they've been charged with a crime and they're going to be arraigned, or they are out of custody, they have been released from jail, but they receive a summons in the mail, paperwork that says, hey, come into court, we want you to appear for an arraignment in order to answer so we can formally charge you with a crime and decide what to do. And in that arraignment stage of things, besides being told what the crime is, a judge has a responsibility to make sure that they decide whether to keep you in custody or let you out of custody during the pendency of a case. And if they're going to let you out of custody, what conditions they need to put in place while the case is pending. And this isn't going to be a discussion of all of the potential remedies that a judge has on conditions of release during the pendency of a criminal case. They are far-reaching. There is an enormous amount of discretion and options for a judge to put in place, aside from just putting somebody in jail and holding them during the pendency of the case. Bail is something that's commonly heard. Certainly, abstinence. Don't drink, don't use drugs, don't engage in criminal conduct, stay away from somebody, wear an electronic bracelet, report every day to somebody. These are just examples of release conditions. When it comes to conditions of release, you have to realize that they're guided by a couple of court rules. You can look them up on the internet. CRR 3.2 or CRR LJ 3.2. One has to do with Superior Court, the other has to do with District Court. From our perspective, and they are fairly interchangeable in terms of what factors judges consider or have to consider when setting release conditions, because the concept of release conditions is pretty simple in some ways. What a judge's biggest concern, or what the rule will tell you, is the biggest concerns a judge should have on conditions of release is whether somebody is a flight risk, whether they're going to appear back in court again and take care of the charge, and what danger they represent to the community. They're going to go out and commit violent crime. Are they going to go out and intimidate witnesses? Are they going to go interfere with the administration of justice in that particular case or in general? It's a very arguable term, administration of justice. And so when you're setting release conditions, and whether it's a felony or a misdemeanor, there's a list of concerns that are outlined by statute that a judge must consider. Now, just on an aside, release conditions address pretty much everything but the highest end of the criminal cases and the lowest end of the criminal cases. Very low criminal cases, minor cases, have things called, have bail charts. They have bail schedules where automatically, if you post X amount of dollars, they'll let you out of jail, and you don't need to go through a formal process of having a judge set that amount. Also, on very serious offenses, life imprisonment types offenses, murder, for example, the judge does not necessarily have to allow bail or let somebody out of jail during the pendency of a case. These are unique situations that you would have to talk to a lawyer about if you needed to get into them further. What we're talking about is the vast majority of felonies and misdemeanors, gross misdemeanors, that people are charged in, and they need to know what to bring into a court or what to talk about. So what I addressed earlier was two areas. One, whether you're a flight risk and whether you're going to appear at future appearances, or whether you're going to be a danger. And let's talk about the 9 factors that the court considers for purposes of flight risk. I'm just going to read them to you. It's easiest that way. We'll talk about them a bit if you need to hear more, or I think it's relevant or it's necessary for somebody to hear more about it. So for future appearances, for flight risk, they want to know the accused history of response to legal process, particularly court orders to personally appear. That's pretty self-evident. If you get what's called an FTA, failure to appear, in a prior case, or you have other cases where you haven't appeared, it's going to be a problem for you. And it's certainly something your lawyer needs to address. The accused employment status and history, enrollment in educational institution or training program, participation in counseling or treatment program, performance of volunteer work in the community, participation in school or cultural activities, or receipt of financial assistance from the government. That's number 2. I often look at that as, let's give a holistic idea of what connections this person has to the community, what their involvement is. This is also where you can heavily document something. You can bring in proof of employment, you can bring in proof of school, you can bring in proof of a lot of things that helps address concerns a court will have with hard paper, which is always a good idea. 3, the accused's family ties and relationships. 4, the accused's reputation, character, and mental condition. 5, the length of an accused's residence in the community. Certainly this can be proved up with leases and or ownership of a house or these types of documents. 6, the accused's criminal record. The prosecutor will have that. 7, one of my favorites, the willingness of responsible members of the community to vouch for an accused's reliability and assist the accused in complying with conditions of release. This is why I tell friends and family, please show up at an arraignment. It doesn't hurt at all. If there's any issue of bail or any issue of concern on the part of a court, having a courtroom full of people that are in support of somebody makes it clear that it certainly factors into whether they're going to appear in court for future court dates. When you have a family and friends showing up saying, we vouch for this person, he will do so, or she will do so. Number 8, the nature of the charge, if relevant to the risk of non-appearance. And 9, any other factors indicating the accused ties to the community. It's kind of a catch-all. Anything else that you can creatively think of that is relevant to why somebody wouldn't be a flight risk, bring it in. As to danger to propensity for violent crime and or to the administration of justice and to witnesses, they have 8 talking points or 8 issues they must consider. They must first, the accused's criminal record. 2, my favorite again, the willingness of responsible members of the community to vouch for the accused's reliability and assist the accused in complying with the conditions of release. 3, the nature of the charge. 4, the accused's reputation, character, and mental condition again. 5, the accused's past record of threats to victims or witnesses or interference with witnesses or the administration of justice. Goes right to the point. 6, whether or not there is evidence of present threats or intimidation directed to witnesses. Again, to the point. 7, the accused's past record of committing offenses while on pretrial release, probation, or parole. And 8, the accused's past record of use of or threatened use of deadly weapons or firearms, especially to victims or witnesses. So this gives you a broad idea, whether you're charged with a felony or whether you're charged with a gross misdemeanor, the type of evidence that your lawyer is going to rapidly want to get together and document as effectively as possible when they're talking to a court about issue of bail and release conditions. It's also important to realize that in the scope of cases that I've talked about, the rules presume that people are going to be released on something called personal recognizance, which is, in other words, it's your own responsibility to appear in court. And what I've talked to you about is that is the presumption of personal recognizance unless any of these factors are of concern to a court. And again, the factors are whether or not you're going to appear in court or whether or not you represent a danger either to the community in general or to the justice system in your particular case. I hope this helps people. Thank you.